All right. All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess.
Please be seated. Good morning. I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
Thank you, Andre.
First case on the 10:30 a.m. docket for Monday, September 8th, 2025 is appeal number 126626, State of Kansas versus Darren Matthew Johnson. Shawnee County briefs both sides.
Good morning, Your Honors. Corinne Gunning of the Appellate Defender Office, appearing on behalf of Mr. Johnson, present and ready for argument.
Good morning. May it please the court, the state appears by Deputy District Attorney Jody Litvin, present and ready for argument.
Second case is appeal number 125865, State of Kansas versus Jason S. Cunningham, Ellsworth County, briefs both sides.
May it please the court, Jason Cunningham appears through counsel Jacob Nowak of the Appellate Defender Office, present and ready for argument.
Good morning. May it please the court. Tyler Winslow, Assistant Solicitor General, appearing on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. We'll now call 126-626 State of Kansas versus Johnson. You may begin when ready.
Good morning, Your Honors. Corinne Gunning, Assistant Appellate Defender, appearing on behalf of Darren Johnson. I would request 3 minutes for rebuttal.
3 minutes is granted.
Okay, to begin, for the reasons stated in this brief, I would ask this court to vacate Mr. Johnson's felony murder conviction and remand for resentencing to second-degree murder as the primary offense and misdemeanor fleeing or attempting to elude. In the alternative, Mr. Johnson requests a remand for a new trial. As I see it, the primary problem in this case stems from the charging decision of the state. It charged Mr. Johnson for a car crash with 2 counts of murder, not in the alternative, and rested the charge of felony murder on a felony that never occurred. There was no question that Darren, in this case, did not stop his car when Officer Scott turned on his lights and sirens, that he ran a red light and turned on to 21st Street here in Topeka off of Indiana Street. But then Officer Scott affirmatively stopped that pursuit. When Darren drove his car at a high rate of speed on 21st Street, ultimately resulting in the crash, he was not being pursued by police officers at that time. He was also not fleeing from committing a felony at that time. At most, the failure to stop on Indiana Street was a misdemeanor fleeing and lewd. At no point did Darren ever commit all elements of felony fleeing and eluding at the same time. That is the question that I have put before this court, is whether or not that is required. And I think the state, I think that the case law demonstrates that if you're going to be convicted of a felony offense, if you're going to be convicted of any offense, all of the elements have to occur together. Generally speaking, unless this court has said otherwise or the legislature.
Let me get back to the
Yes.
question of the pursuit. This kind of presents an interesting question. When you watch the two the cams that are on the vehicles, it almost appears that there's very little separation between Officer Scott deactivation of his lights and Officer's good pursuit of the vehicle. Is there any kind of, is there a buffer? Is there some sort of, does it have to be continuous? What?
I would say that
As soon as you deactivate your lights, the pursuit is over? Is that what that is? Is that how we look at that?
if I'm looking at the elements of the offense, yes, because it's activate lights and sirens pursuing police vehicle. From my perspective, I maintain that Officer Good never pursued. There was never a pursuit by Officer Good. If I'm remembering correctly who he was, had started the process of potentially beginning a pursuit.
Well, he observed, it's pretty clear he observed this car flying through a red light
Correct.
and turned and immediately started pursuit, activated his lights and began a pursuit. And then you can see the accident occur.
Yeah.
Not quite simultaneously, but almost simultaneously with that action.
And if we look at what Officer Good's statements are, he even testified he hadn't really had the opportunity to start a pursuit before the crash happened. And I understand the difficulty of, I mean, everything in this case happened very quickly.
Within 30 seconds, a minute to 30
A minute, yes. And so everything happened very quickly, but we still have to have all of those elements occur together. And I don't believe that we had a police pursuit at the time that Darren was arguably driving recklessly.
What in the statutory language requires them to be simultaneous in time? All I see is a knowing failure to stop once given an audible or visual signal and involvement in a motor vehicle accident. It doesn't say they have to happen at the same time.
As I put in my brief, I won't know the case off the top of my head. I apologize for that. The appellate courts have largely held that the elements do have to occur together, that you can't have a case unless we have some sort of continuing offense. It's audible or visual signal of a pursuing police vehicle. And when we don't have a pursuing police vehicle who has an audible or visual signal to stop, I don't think that we have a fleeing and elude, because we don't, at that point in time, how is the person supposed to, I mean, I understand.
I mean, your argument suggests that as soon as the officer disengages the chase, that the driver of the fleeing vehicle doesn't have any obligation to stop. Is that right?
That's my position, yes. And
Is it right under the law? I mean, I understand that's your position, but under the statutory language, what would suggest that?
Because you're not fleeing from a pursuing police vehicle if they're not giving you a signal that you have to stop. And I mean, I think just like from my perspective, a logical perspective, if a police car is behind me and they don't have their lights and sirens on and they're not giving me but they stay behind me for an extended period of time, if they then tell me that I fled from them because they were pursuing me, because they were following me, how was I supposed to know that I was supposed to stop? In this case, I understand the facts are different because we do have some bad conduct that does occur. But I'm not sure that it's fleeing and eluding amounting to a felony. Certainly, I mean, I have no problem in this case. I had no argument in my brief that this was reckless conduct, which is second-degree murder. And for most of the time, a car crash that occurs like this is a reckless second-degree murder. I think there were two distinct periods of time here when Darren was on Indiana Street and then when he was on 21st Street. And on those two separate streets, not all of the elements of felony, flee, and elude come together.
Why doesn't reckless driving come together with his actions in the initial pursuit? When Officer Scott turns around and activates his lights, observes the vehicle speed, and you look at the video, it's a very narrow road with no curbs, tree lined, residential area, and runs a red light. That's pretty clear. You can see that when he's pursuing. Why aren't all those factors fit with reckless driving?
I'll have two answers.
And other factors, just
I'll have two answers to that. I'll be honest, yesterday, as I was preparing for this argument, I watched the video from Officer Scott's dash cam ad nauseum. And there's a 5-second period, 4 to 5 second period from when he turns his lights on to when Darren turns on to 21st Street. And in that period, he's down the street, you see his brake lights go on and he goes through the red light. Both of those two things, I mean, I suppose you could say that he is speeding. I think that's a factual question for the jury on whether or not he's speeding on Indiana Street. Officer Scott said he was, and then he went through a red light. Those are two moving violations. And so my argument would be that if we say that those two independent moving violations where nobody is around and where there's arguably no danger in that area for harm to another person, I think we don't have reckless conduct. We have 2 of 5 moving violations in a pursuit, which is another way to get to felony, flee, and elude. And the alternative, my answer is, then that would be a fact question for the jury. whether or not that is reckless conduct. And in this case, the jury maybe could have made that decision. I don't see the state in its case arguing that. I know that this court has not necessarily held the state to what arguments it presents at closing. The state largely rested on the speed at the time of the crash and the crash itself as the reckless conduct. But if we're going to leave that to a jury, they should have a definition of what reckless conduct is, which has a specific legal definition that they didn't have. And some people might just in their mind say, well, I wouldn't run a red light. I think it's reckless to run red lights. Was it wanton or willful conduct that can lead to injury to other people or damage? And they didn't get that instruction. And so I don't think that they had the proper lens in which to view that conduct and whether or not it was reckless, if we're going to look at that right there as supporting the reckless.
Couldn't they have looked to the other instructions that defined reckless?
I would say no, because reckless driving itself has a specific definition in the statutes that does not match the state of mind instruction necessarily.
How's it different? Because the statutory definition of reckless driving is willful or wanton disregard for the safety or persons of another. How's that different than a conscious disregard of a substantial and justifiable risk that's a gross deviation from the standard of care?
I think it specifies, wanton or willful is, I would say that's, I know conscious, but wanton or willful is a more specific choice.
It seems like a broader choice because the reckless definition, the general definition, almost seems to cover wanton, but not necessarily willful. But the statutory definition of reckless driving is willful or wanton.
I think that's more specific than sure, yes, it's more specific than just disregard, I think. And then we're talking about a specific result rather than a general result that might occur. And this, the appellate courts have said that when we don't give that instruction, when we're charging felony, flee, or elude, the jury doesn't have the right frame for which they're looking at it. I know in some of those cases, we don't have another crime that has the reckless element in it. So that question hasn't really necessarily been resolved.
But those are separate issues, right? One's the sufficiency question.
Yes.
And we look at the evidence in the light most favorable to the state to resolve that issue.
Yes.
But so your sort of second argument and response was, well, then we turn to the instructional error issue.
Yes.
Right. Okay.
Yes. So it is my position that this court can find that did not amount to reckless conduct and that no jury would find that it is reckless conduct. And then in the alternative, if there's a question there, it's a question for the jury to resolve and they didn't have all the instructions that they needed to resolve that question. I do see that my time is up. So unless there are further questions right now, I'll reserve the remainder of my argument for rebuttal.
I see no questions. Thank you.
Good morning again. May it please the court. The state appears by Deputy District Attorney Jody Litvin. I will continue on with the discussion today of the first issue. And our position is that the state presented sufficient evidence here of the felony fleeing or attempting to elude a police officer. As Justice Siegel was pointing out, nothing in the statutory language or plain language of the statute supports the defendant's argument.
Well, I'll flip it around now.
Okay.
Which is, I guess, a warning on not taking a question to mean that's my position necessarily. I think there is an answer to that question from our Irvin case just recently, in which we basically said, look, the elements do have to happen simultaneously, and a jury cannot, I'll just reading, the jury must limit its consideration to the driving during the pursuit and may not look at his actions after the pursuit ended. How do you get around that or distinguish it?
And I was looking to see if I could find the specific facts in Irvin, and I didn't do a deep dive, but I don't know what the testimony was about the pursuit. If the officer said, I know in the opinion, I think it said they were told to end the pursuit and they ended it. So here, I don't think we have the same evidence of the end of the pursuit.
Well, how do you deal with Officer Scott's testimony? His testimony when he said, no, I was driving the normal speed limit without pursuing the vehicle after he turned off his lights and sirens. How do you get around that?
The way that I think that the state is viewing that testimony is to link pursuing with lights and sirens. It's a departmental policy. I think there was some testimony that we have to end the pursuit, meaning we have to turn off our lights and sirens. And that's not the same as what the statute says in pursuing. Pursuing isn't connected to lights and sirens. So I think we're talking about a departmental policy of we have to end the pursuit, meaning turn off our lights and sirens. That doesn't mean that he is not, as pursuing is defined, following in order to overtake or capture. He said he was still turned, I think it was turned left onto 21st Street. He was still going in the direction of the defendant where he went, although he did lose sight of him. But because he lost a visual, he was complying with the department policy to turn off his lights and sirens.
Your argument is that pursue, the legal definition of pursue is broader than lights and sirens.
Yes.
And that was the precise issue, although in a different context, that we considered in the Irvin case. There's just some language in there that really cuts against your argument, but I wanted to explore whether perhaps Irvin is a case of potentially unintended consequences. Another line of.
Just if I can interrupt it with that, in Urban, I believe the facts were that the police officers turned around. They went into an entryway and actually turned. So your distinction between lights and sirens and pursuing was really not at issue in Urban.
Right.
Factually. So
but there's some
go ahead.
dicta, which I was getting to in Irvin. For example, I'll read another line. The reckless acts considered under the fleeing and attempting to elude count must have occurred while police car lights and sirens were activated. I mean, if that's right, it's the facts here strike me as it would be difficult for the state to make out its case. But then obviously the follow-up is that right?
Sure. And I guess I would just say this court still didn't define what pursuit was.
Right. The context here was whether or not the jury needed to be given an instruction defining pursuit, and the Irvin court, we said, no, you don't need to define pursuit, but just I'm concerned about, I wanted to hear your responses to some of this language that was used in that decision.
And I agree that, and knowing the facts, Your Honor, now, if they did turn around and really end the pursuit and that was the evidence that was shown, I think that's different than the evidence that we have here. He never stopped pursuing. He turned off his.
For you to prevail, do you need us to disapprove some of the language that we just published in our?
I hadn't thought about that. I don't know. Maybe you could just do a factual difference. But I do think that linking the lights and sirens to pursuit is not supported by the statute.
But you would agree or concede that in this case, the accident occurred after the lights and sirens were terminated or turned off?
Yes.
Okay.
I think, yes, based on the videos. And I think the reason I hesitate on that is because I think Officer Good's testimony was, I was in the process of turning on my lights. This all happened as Your Honor said.
Bang, bang, bang. And your argument is from the bang, bang, bang nature of it, it's silly to just look at lights and sirens because we should look at the pursuit globally and conclude the pursuit was ongoing.
Correct.
Okay.
Correct. And I think it's a dangerous precedent to say lights and sirens off, pursuits ended. That's not the way that plays out. And that's very dangerous. So I think it's different here. I think it's not their argument's not supported by the statute.
Let me ask a question to follow up on Justice Rosen's. If we go to reckless driving, so it's my understanding that Officer Scott testified that when the lights were going and the sirens were going, okay, so we have this active pursuit, that Johnson accelerated and continued to accelerate as he traveled above the speed limit for a few blocks before running a red light to turn left onto Indiana and that the body cam footage, which was played for the jury, showed that it was dark outside during the pursuit and that the street that he turned on was lined with trees, suggesting that, you know, maybe oncoming traffic wouldn't have been or limited or whatever. So if that is, you know, so could we say, okay, the question presented is whether that is sufficient to prove or to establish reckless driving under, you know, I understand that the definition wasn't given or whatever, but, and then when you do that, and then you look at the felony murder statute, which says whether, and I had it down, what, you know, that if, you know, the felony is, the murder is either before or during or after, you know, the underlying felony, then do we get there that way, or is that not a good way to go?
Let me see if I'm understanding your Honor's question. Is it just, are we talking about what facts do we have to support that there was actually reckless driving during the time that the lights and sirens were on? If the court wants to go that way with pursuit equaling lights and sirens on. I think that the testimony from the officer was that when he initially saw the Kia, he turned around, turned on his lights and sirens, and he saw the Kia punch their acceleration. So an excessive amount of speed on a residential area, and then blew through that red light. Granted, it's 4 or 5 a.m., so maybe there are not that many cars out, but that doesn't negate the fact that that was really reckless behavior to go almost, well, when he wrecks 30 seconds later, a minute later, he's going nearly twice this, 80 miles per hour or more. At 100 miles, he reaches 100 miles eventually. Right. So I don't think that those two things in combination are not reckless. I don't think that there's any way that we can argue that it's not. Punching the acceleration, clearly having seen the officer, lights and sirens on, boom, go, blow through a red light. And then if we watch the Axon video from Officer Scott, seconds later, there's a car that comes through that intersection at 21st and Indiana. Had he been there and blown through that red light right then, there could have been the accident then. So I think that does establish recklessness. If we're going to go with, you have to have reckless driving while engaged in a pursuit, and pursuit equals lights and sirens, that's that. If not, I think Your Honor maybe is talking about my alternative argument of, if we don't find that that happened engaged in reckless driving or a motor vehicle accident during the pursuit, it's certainly the flight from a completed flee and elude like this court had in Urban. So I think under the felony murder, you can get there that way as well. Because it happened all within the res justi of the case. And then Your Honor, I want to make one more point. I think that I think got written down. Going back to Urban and the definition of pursuit, I think there was actually language in that opinion also that talked about if that definition would have been given, it would have been actually misleading. And that pursuit definition talked about you don't terminate the pursuit. I can't remember exactly what the instruction did, but I think that also bolsters our case to say that if that definition of pursuit would have been given and this court found it was like a misleading or not proper, that's kind of what we have here. So I wanted to get that out before I forgot that. And unless are there any further questions?
Clarify your position on the lack of a definition of reckless in the reckless driving instruction. Are you suggesting that it was legally appropriate because all of the elements of the offense were in the jury instruction, and then you look to see if the definition, or was it, what's your position on that? I think the defendant's questioning the legal appropriateness of it without the instruction, without the definition instruction.
Sure, Your Honor. I think that we recognize that the PIC instruction, whatever PIC instruction that is, 66-110, does say under circumstances where reckless driving is used, it should be defined pursuant to the statute. It wasn't here. Just because that's incomplete doesn't make the instructions as a whole or that instruction legally incorrect. And I think that's the distinction that we're making here. And a couple of important concepts that this court looks at, we look at the instructions as a whole to figure out whether they've misled the jury or whether they were legally incorrect. And there was 2 other instances here where recklessness was defined, granted not in that PIC instruction, but the absence of that doesn't mean that recklessness wasn't defined as a whole to the jury and given to the jury. I can't remember the other 2 instructions, the second degree murder and I think the lesser.
Doesn't that kind of go to a harmless analysis? rather than whether it was legally appropriate?
Well, we're in a clearly erroneous.
Well, it was defined somewhere else so they could reach the conclusion.
I mean, I guess I think about it as, can he meet his burden to show that it was clearly erroneous? And I think that helps to show that he cannot, because there was these given, because we're not really in harmlessness because this wasn't requested here. But
I meant clearly erroneous.
yes, I think that goes to show that he can't meet his burden because it was. And again, there's also language from this court saying not every specific term needs to be defined. And even if this wasn't in the pick, I think we could argue that this is a known term that the jury could understand and didn't need the specific definition of recklessness. And then if the court has no further questions, I guess I can quickly hit on the prosecutorial error claims. There are kind of two categories here of prosecutorial error: misstatements of law and inflaming the passions of the jury. And the state here would argue that the prosecutor did not commit error in any of these comments or statements. He did not misstate the law and didn't inflame the passions of the jury when talking about holding the defendant accountable or going after the bad guys. That was a statement on the evidence. And then their kind of isolation of their last argument as to the inflaming of the jury, where the prosecutor said it's based on the evidence because the evidence supports it. That's why you should convict of first degree and second degree murder. That's unquestionably a proper statement by the prosecutor. And just for all the reasons set out in the brief, we would argue that there was no prosecutorial error here and harmless error alternatively if this court does find any. But other than that, I don't think I have any further presentation, Your Honor.
Any other questions? Okay, thank you.
Thank you.
I'd like to start back with the question of, was there a pursuit? As I've heard the state argue here today, is that the pursuit never ended. And in my view, their brief says differently. They conceded that the pursuit had stopped. On pages 14 and 15, they acknowledge Officer Scott's statements that the pursuit had stopped. So if we go with what I'm hearing some of the discussion here today, to say, well, he said the pursuit stopped, but he was still following. I'm wondering what a jury is to do if they hear this testimony that says, I was not pursuing, the pursuit stopped. I was not in pursuit. I had not started my pursuit. And then the state argues in their closing argument, of course he had to stop his pursuit. We have these rules. Of course there wasn't time to start a pursuit. He's driving too fast for a pursuit to begin. And that's what the jury has in making its decision, where an element is a pursuing police vehicle. And then we come here to the Kansas Supreme Court, and this court says, well, it doesn't really matter what he said. It matters, like, well, are we continuing this pursuit? Is he still following him? When does it stop? I don't know what a jury is supposed to do in those situations when they have testimony, when they have argument that says there was no pursuit.
Well, in Irvin, just to go back to that most recent case, which seems to be pretty important to this case. There is some language in there that I think you heard me question your opposing counsel that arguably supports your point about lights and sirens.
Correct.
But the ultimate holding might cut against you when we said pursuit does not need a definition with a jury. So why isn't this just a jury question? They got the elements and they could decide, had the pursuit ended or not? And under these facts, why was it unreasonable for them to conclude that the pursuit had not ended when they consider the totality of the circumstances?
Again, I kind of have a two-part answer there. First, I think I love being able to talk about the facts of Irvin and not just jail credit with Irvin. But like with Irvin, one, the issue is not the same. There wasn't a challenge to the felony fleeing and eluding. It was really to the res gestae part of it. But in this case, if we have the pursuit, if we have two people saying they didn't actually have a pursuit, at one point there was a pursuit. And I think that the jury, I have no argument that Officer Scott wasn't at some point pursuing that vehicle. And that he didn't stop. And those are all the elements of misdemeanor flee and elude. So I think that we do have the misdemeanor present. We weren't given a misdemeanor instruction. We weren't given that as something for the jury to consider. And the state, I think all of this comes together, which goes to my cumulative argument, but all of this comes together. The state made these arguments saying, well, we had a pursuit here. It doesn't matter that it wasn't happening at the time that we have the reckless driving. And the argument was that the reckless driving was the 70 or 80 miles an hour on 21st Street. The argument was that the crash are the things that are elevating the offense. The argument of the state was not when he accelerated on Indiana Street, that was reckless. But the argument there is we had a pursuit and we had the crash. And because those two things did happen, it doesn't matter if they're happening together or not. And that is the basis of my prosecutorial error. So I think this court still can find that there was not evidence, but I also think that the jury was not given the right frame of mind in which to look at the evidence based on the argument of the state.
How can we ignore the res gestae under that argument? Because was he not alluding at that point? And we're talking seconds, right?
Yes.
We are talking seconds. And so why is he not eluding the pursuit?
The argument in order to get to the felony fleeing and elude and the felony murder is that pursuit did not amount to felony.
I'm sorry,
was not felony fleeing and elude. That
So-
pursuit and the higher speed. I mean, I hope that you all watched the videos and have watched the videos. The higher speed on that road and the turning was not reckless driving per the definition. So it was only a misdemeanor. And if you're fleeing from a misdemeanor, that's not felony murder.
So it all comes back to that question.
Yes, is whether or not there was ever a felony flee or elude. And my argument is that there was not, and therefore there cannot be a felony murder for fleeing from a felony flee or elude, which again was not the question in Irvin. I think there was no question in Irvin that he was committing felony flee or elude. I do have questions about whether or not he was, the time of the turning off and things like that, because it was having watched the video in that case, it was immediate after the lights and sirens went off and on a very busy street. But that also, it just wasn't the question in Irvin as well.
Well, and the state is actually the one who in Irvin told the jury, once the lights are off, pursuit's ended. I mean, they define pursuit that way, and that's why that discussion occurs there.
I would say,
and contrary to what the state's arguing here.
And I would say in this case that, I would look at Officer Scott's testimony as telling the jury that lights and sirens off means the pursuit is stopped. That's what I took from his testimony.
And well, I don't think we need to go, but we did use a broader definition than that in Irvin. We used the Black's Law Dictionary, which is the act of chasing to overtake or apprehend, which could be without lights or sirens, arguably.
Right, and my perspective is because the lights and sirens is part of the, and the legislature doesn't go, bullet point it the way that the PIC instruction does, but it's a list of, a pursuing, that you've failed to stop after giving a visual or audible signal to stop for a pursuing police vehicle. And so since I see nothing there that indicates that the legislature does not intend for all those things to happen together.
Well, what if an officer is on foot and he shouts, "Stop, police"? Does he have to keep shouting "Stop, police" every 5 seconds?
I think that he should be continuing to give some sort of signal, visual or audible signal to somebody.
You think that's what the statute means? That this audible or visual cue has to be ongoing? Or you just get it once and then you got it?
I suppose that my first note is that we have a completely different statute for officers on foot, that this is vehicle, pursuing police vehicle. So I'm not sure that we have the same conversation.
Do you think it might be different?
It might be. I obviously do not have that statute at the top of my head, but we do have a relatively recent new statute for police foot pursuits. This with the statement of a pursuing police vehicle seems to indicate that their visual audible signal is lights and sirens. I can't think of another.
But it also includes police bicycles. The statute is pursuing a police vehicle.
Yeah, a bicycle is is
Which-
included in that, yes, which I think do have I mean, the ones I've seen from the Capitol Police do seem to be equipped with equipment
With some kind of light.
of lights and maybe a siren. I've never been stopped by a police bicycle or seen
Or-
stop. So with that, if there's not any other questions, I would ask this court vacate the felony murder conviction as well as the flee and elude and remand for resentencing to second degree murder, or in the alternative, remand for a new trial with a proper instructions on these offenses.
Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement. To explain what that means is that later today, we will begin discussing the issues in this case. And we will continue that discussion until the group reaches a decision as to the outcome. One of the justices will then begin writing a majority opinion in that case. It is possible that there will be disagreements, in which case separate opinions may be drafted by other justices. Once we reach a final agreement as to the wording of that decision, which, as you can tell from our discussion of a recent case, we have to be, that wording will, can make a big difference. And so there's some time spent trying to make that writing as precise as we can. At any rate, once that decision is written, it will be posted on our website. It will be posted and available through other mechanisms as well, where anybody can read the entire decision to understand what went behind our thinking and the reasons that we reached the decision we do. So with that, thank you, counsel, again. We appreciate your arguments. We'll now call the final case of the day, 125865, State of Kansas versus Jason Cunningham.
May it please the court, Jason Cunningham appears through counsel Jacob Nowak, the appellate defender office. Chief Justice, may I please reserve 3 minutes of my time for rebuttal?
3 minutes is granted.
Thank you. As I drafted the petition in this case, my largest gripe with the Court of Appeals decision was one of a perceived logical inconsistency, and that they were applying a rationale to sexual works of art that I was more than reasonably confident they would not apply to other unpopular works of art. And to that end, I drew upon my own personal experience as a horror movie fan. I enjoy horror movies, particularly slashers like Friday the 13th and Scream. And those movies, at their core, what they do is they depict and glorify violent acts. And yet I'm positive that despite this disclosure, no one in this courtroom thinks that I now have a propensity or proclivity to go out and engage in violent acts on my free time. And so it doesn't make sense that we would apply that same rationale to sexual works of art, specifically pornography in this case. And as I began to thought about this issue more, I realized that what the Court of Appeals did isn't necessarily novel. It might be new to Kansas appellate case law, but society in general tends to criticize or demonize new art as it is released. To that end, I think it makes sense because the bulk of art is produced by and for younger generations. You know, there's an old observation at this point that if you ask someone what their favorite musical artist is, they were more likely than not say somebody who was popular in their 20s, because that's an age where people's artistic consumption is at its height. That's an age when tastes are still being developed. And at a certain point, everyone's artistic tastes do kind of get set. Not that they're completely finite, but a little more rigid. And so we've seen this historical pattern of art being criticized as it comes to fruition. A couple of the ones I lived through is in my younger days, they told us that video games, particularly violent video games such as Mortal Kombat or Grand Theft Auto, were going to turn us into deviants who had a propensity to commit violence. They said similar things about Harry Potter, of all things, that it was going to turn us into devil worshippers, which they also said about, before my time, Dungeons and Dragons. And throughout history, we've kind of said similar things about different genres of music as they've come, that they were going to rot the youth's brains, be it rock and roll, hip hop, rap, heavy metal, or what have you. And the thing about that historical pattern is, after a few years, we always seem to decide near unanimously that those fears were unfounded, that those claims were not credible. And so I'm hoping as we get into this discussion today that we can realize that since we've all applied that logic to the art that came out during our generations, that we can also apply that benefit to the art that is being produced by and for younger generations. And to an extent, that's what this court recognized in its opinions in Smith and Boland. Now, admittedly, it didn't wax poetic about the pursuit of art in the face of adversity, but it recognized that key component that watching pornography, whether it be homosexual pornography, heterosexual pornography, it has no relevance on whether or not the person consuming that pornography will engage or even have a desire to engage in the behaviors depicted therein. And for a while, that was just how the rules were applied. I did trial work, and I've never had this come up where a prosecutor was asking to get pornography admitted, probably because we had those cases. Recently, we had a decision in State v. Sheets, which, as I interpreted it, created a narrow exception to those cases, because the state did ask this court to overrule Smith and Boland when it was up here in State v. Sheets. And it also asked this court to carve out an exception from State Boland for incest-themed pornography. The court didn't do either of those things. Instead, what it did, and it's important to note that Mr. Sheets was charged with multiple counts, including 2 counts of aggravated sodomy, 2 counts of rape, and 1 count of sexual exploitation of a child. It determined that that evidence was relevant not towards the rape and not towards the aggravated sodomy, because that holding would conflict with Smith and Boland. It found it relevant only as it applied to the count of sexual exploitation of a child, which is a crime that prescribes a particular possession of a particular type of pornography and not a real life sex act. And so when you synthesize these cases, which I think anyone analyzing the relevance of pornography in today's age needs to do, you can kind of see pornography is irrelevant as opposed to a real life sex act, but it is relevant to determining what type of pornography the defendant may or may not be interested in watching. Back to my horror movie analogy, again, it doesn't make sense to say that someone who likes Friday the 13th would engage in violent behaviors, but it does make logical sense to suggest they might also enjoy Scream because that is a relevant interest to the art that they're watching. What art you look at can tell us maybe something about what other type of art you might be interested in. And so I'm asking this court to essentially recognize that, because what the Court of Appeals did was it refused to read Sheets that way. It read it as broad and controlling on this issue as if there is ever an element of sexual gratification, an intent to have sexual gratification or arousal, then someone's pornographic possession or consumption would be relevant towards establishing that element. But you can't.
Where do you pull that out of what the Court of Appeals did? Because, I marked on page 6 of the Cunningham decision where the Court of Appeals said that, Sheets held evidence of prior sexual misconduct, and then quoting, may be relevant to a person's sexual desires when those desires are material facts necessary to prove an element of a charged crime. And then the Court of Appeals goes through and looks at each one of the counts and associates materiality to that. I don't see some kind of an automatic, if you've got dirty pictures, it automatically comes in. I see the Court of Appeals as saying that, it may be relevant if it ties back to these elements.
Right.
So where is the language in the Cunningham decision that says this is an automatic admission of evidence. I don't see that.
Well, they're saying it's automatically relevant, I suppose. There's obviously questions
Where is,
beyond that.
what does the panel say that causes you to find that interpretation? That's all I'm asking. I know I got the decision right in front of me. Where do I look here to see what you're saying the panel did?
Right.
Because the parts I've quoted tell me they didn't do that.
Well, it's the parts you quoted that then lead into them going into the statutory elements and emphasizing the intent for sexual arousal and sexual gratification. That's where they're saying that is the disputed element that is at play in this, that this becomes material too. And the problem with that is that those elements were at issue in Smith and Boleyn. Those two defendants were charged with aggravated indecent liberties with a child. So they're the issue of whether or not they acted with an intent to obtain sexual arousal or sexual gratification was at issue. The problem with it, the pornography, is that it's not that those things aren't material. It's that this court has already recognized twice now that that isn't probative towards establishing that material fact. That's what we have in State v. Boleyn and State v. Smith. The court went into it in great lengths in State v. Smith, where it described how that's inconsistent with what we said in Boleyn. It is inconsistent with this scholarly article that we've cited to from the Archives of Sexual Behavior, and that if it is not going to be relevant to prove that someone might have a homosexual tendency, we're certainly not going to say it's relevant to prove that someone has a heterosexual tendency. And so if you can't assess the relevance of pornography without divorcing it from Smith and Boleyn at this point. And I'm not, I suppose, here to say that Smith and Boleyn can never be challenged from the state, either generally or more specifically on a fact-specific basis. But in order to do that, you need to do it at the district court. You need to recognize that adverse authority from the get-go, but that's not what happened here. Essentially, whether it's intentional or not, the state prevented the court and defense counsel below from doing research on this court's authority as it pertains to lawful pornography, because they came in and they said it's the same thing they did in Sheets. They came in and they said they filed a pretrial motion to admit 6455D evidence, claiming that they were going to present evidence of child pornography, which would be a whole different thing. That would just be admissible under KSA 6455D. They used that motion to secure a pretrial ruling. So we don't have the court and counsel reviewing this court's authority on the inadmissibility of lawful pornography. Then at the 11th hour at trial, right before the witness shows up on the stand to testify, the state concedes and acknowledges, turns out we can't actually prove that it's child pornography. It's just ordinary pornography, but we still think it's relevant for whatever basis the jury will give those those titles. And so that is how it went in both these cases, which is why we don't get an acknowledgement of Boleyn and Smith below. And to the extent that the state is ever going to differentiate those cases, it really needs to put on evidence to explain one way or the other why the district court should be differentiating those cases.
So if you take their Court of Appeals statement that Cunningham's intent to arouse or satisfy his sexual desires was an element of multiple charges against him as a justification, which you're rejecting. If that sentence said his sexual desires focused on a child, would that make a difference? Where 9, or I think it was, of the 11 were very focused on a child as the victim and or a child of a parental figure against a child of the opposite sex.
I'm not sure how it would in this case necessarily. I mean, again, all the pornographic search titles that were admitted by the state in this case, they did not prove that those were sexual exploitative materials. The presumption is that is lawful pornographic material depicting people depicting adults engaged in consensual sexual activities. So no, I don't see how that particularly would connect towards an interest in younger individuals. Now, again, if it were sexually explicit material of a child, it's absolutely relevant at that point, pursuant to KSA 6455D, but that's not what happened here. That's not what we have. This is just general lawful internet pornography, as I understand it.
Even if lawful, wasn't the titles intended to depict something closer to unlawful? And I think this is really just a follow-up to Chief's question, that the specificity here, the titles themselves, regardless of the lawful status of the content, were at least consistently incestuous and non-consensual. Which seems to be, we're not just talking about this general category of pornography. I mean, the specificity of those titles, does that make the inferences more reasonable under these facts?
Before I answer that, Chief Justice, I see I'm out of time. I believe.
Certainly.
Thank you. No, I don't believe so. So there is, I think, a broad range here. We have some incest themed pornography. We have some rape fantasy themed pornography. We have things that have nothing to do with either of those contained in this image or this list that was presented by the state and admitted below. I don't think the specificity necessarily carries the day here for a couple of reasons. One, it's frankly not that specific to this case. We're a couple of categories of incest removed here because all of the in here is biologically themed incest, but there's also step incest pornography that's not listed in here, and there's also pseudo incest pornography that doesn't get listed in here. That would be far more specific to the fact pattern we have, because my client wasn't accused of committing incest in this case. He was accused of abusing a child, but these don't on their own indicate that it is pornography of someone abusing a child. Again, if it were, we wouldn't be having the discussion we're having today. The question is whether incest-themed pornography generally, which again, I'm going to assume that this is all people who are in their late 20s, early 30s, pretending for the sake of producing art, or I guess acting is a better word than pretending. The question is whether that sort of material would be relevant to a child abuse case. And I don't see how it would be based on at least the specificity situation. And again, to the extent it might be, all we can do here on appeal is kind of take a little post hoc fallacy argument towards it, which is, well, it's fairly specific, so it must have caused the other thing. But really, without developing that record below, without putting on something from anyone to explain why those two dots would connect, I'm not sure we can do that on appeal, particularly in light of this court's holdings in Smith and Boleyn. And with that, I will make myself available for rebuttal, but unless there are any outstanding questions, I will sit down.
Good morning. May it please the court. Tyler Winslow, Assistant Solicitor General, appearing for the state of Kansas. Firm and fair blows in a child sex case. That's what this case ultimately boils down to. And because the prosecution's presentation of KSA 6455 evidence of the bookmarks that have been discussed and in argument, because those were firm and fair blows, the state asked this court to affirm the Court of Appeals decision in this case. Stepping back to the facts for a second, I'll use the pseudonyms because I think they track nicely with the Court of Appeals opinion in this case. But broadly speaking, Jane tells a friend at school that her stepfather is raping her. A classmate overhears that, and that's when the investigation begins. The Kansas Bureau of Investigations dug in and identified not one, not two, but a total of 4 child sex victims for Mr. Cunningham. 2 of those resulted in charges, and 2 of those testified under KSA 6455. Further into the investigation is when a phone extraction yields bookmarks which the Court of Appeals documented in its opinion, and which are now the focus for this case in terms of relevance and undue prejudice. Any tendency to prove a material fact. It's a low burden. And so any arguments that perhaps incestuous themed titles like Daddy Teaching Daughter How to Quote, Suck and Fuck, apologies for the terminology, but that's what we're dealing with here. Any tendency to prove a material fact. This is a child sex case. The relationship between Cunningham and the victim in this case is that of I think she's referred to broadly as a stepdaughter. Ultimately, I think they were girlfriend, boyfriend. I think there was a dispute about the relationship between Cunningham and the victim's mom. But ultimately, it's any tendency. Broadly speaking, Boleyn, from the state's perspective, does not stand as an absolute bar to the admission of evidence like this. It's about what the extent to which, and what the holding is actually, is the extent to which admissibility of a pornographic preference might apply when a witness says they are open to multiple different types of physical sexual encounters. In that case, it's a bisexual individual. The pornography to be admitted, I think, via stipulation was a preference for same-sex, for gay pornography. So Boleyn does not stand as an absolute bar, is the state's position here. And ultimately, this court's already addressed, as its application for this case in Sheets, how Boleyn, how Smith, and another unpublished Court of Appeals opinion all play into this type of evidence, because there's ultimately no real distinguishable fact between this case and Sheets. The state relies on Sheets for its argument, and ultimately, in Cunningham's case, the bookmarks served as corroboration to Jane's testimony. Particularly given that she recalled some of the titles that she had been shown, and they're relevant to showing specific intent, which is exactly what the Court of Appeals referenced. I'll turn then to the prosecutorial error. There are two comments at issue. The Court of Appeals found neither to be error. I'll ask this court to do the same. Addressing the first comment, so if the event happened, which the state believes that it did, this is in discussing what became known as the chocolate popsicle incident at the trial court. What the prosecutor is actually doing in this case is talking the jury on to the timeline to show Jane's age when the allegation occurred, when the chocolate popsicle incident occurred, because the state had to prove her age for that charge. So it was perfectly proper for the state to make this argument, to talk the jury on to the relevant evidence, which included Jane's testimony. Secondarily, Cunningham testified, and as part of his testimony, he discussed a quote-unquote mini trial that Jane's mom called him and discussed this chocolate popsicle incident. But according to Cunningham, it occurred before Jane said the allegation. The state's argument invited the jury to consider the efficacy, whether or not they could believe that argument, and ultimately argued that his own testimony actually corroborated Jane's allegations. Finally, turning to the cumulative error, and I'll address harmless error at the same time, because I think even if this court were to find error on all points, any error is harmless beyond a reasonable doubt. Notwithstanding any of the errors, if this court were to find any, Jane and Mary's testimony remains unchanged. So do the additional testimonies of the uncharged victims. There's still a propensity argument available should this case ultimately have proceeded without the background, the bookmarks or without the prosecutorial error allegations. In addition to that, Jane's allegations are corroborated. They're corroborated by a box of sex toys found in Cunningham's closet and their location, as well as the panty collection, in addition to the forensic interviews that were introduced at trial. So ultimately, the state asked this court to affirm in accordance with the Court of Appeals. Pending further questions, I'll stand on the written brief.
You discussed the relevance argument you've provided for us. What about undue prejudice? What's the state's position there in terms of responding to any argument that even if it just barely passed that threshold, the prejudicial force of those bookmarks might have warranted exclusion? Yes, Your Honor. First and foremost, I'll point to the corroborative portion of the relevance, right? Jane's, the forensic interview discussed videos that Cunningham showed her. The titles that she discussed, not a verbatim quote for sure, but how else would Jane have known of these titles? First and foremost. Secondarily, the importance of the charge. The state had to prove beyond a reasonable doubt Cunningham's sexual intent for, I think it was 4 of the charges. And so because of the requirement that the state prove those charges beyond a reasonable doubt, that cuts against the undue prejudice argument, and a finding that it would be unduly prejudicial that the bookmarks come into evidence. Seeing no further questions, I'll stand on the brief. Thank you.
Thank you.
May it please the court, 2 things. First, the state used the word perfectly proper when it was discussing the first prosecutorial error I alleged, which was the vouching for credibility of the victim in this case. Due to the context, I suppose, that the statement, "we believe her," was made in, that's never going to be perfectly proper. I've heard this court repeatedly refer to that particular prosecutorial error as touching the 3rd rail. You touch it, you die. It is an egregious error to commit. It is reversible error. The second thing I wanted to point out is a little bothered by the fact that the state referenced the bookmarks in this case, again, with ambiguously at least, because issue 2 of my petition for review asserts that the Court of Appeals materially misstated that fact, that this was a Celebrite extraction report that Agent Celeste bookmarked, and that the Court of Appeals materially misinterpreted the record when it said that my client bookmarked these videos to his search bars of his Internet Explorers. And that's not simply a situation where the state can just say, well, maybe the record's ambiguous, even though I don't think it is. The Attorney General's office compiled and produced this exhibit. Pursuant to Brady v. Maryland, we impart actual knowledge. They know or should know whether or not that report says my client put these onto his search bar as bookmarks. I'm a little bothered that they have not notified the court one way or the other, because in State v. Sheets, this court said we have a duty to correct material misstatements of facts in the Court of Appeals opinions. And to the extent they are suggesting that Agent Hackmeister may have misspoke during his testimony, well, that would be perjured testimony, and they also have a duty to correct that. So I'm bothered by the fact that they have not addressed that one way or the other, because I don't think they can take the position they took in their response to my petition for review. Finally, it's, again, goes back to what the state's argument is the same thing that the Court of Appeals did. If they're continuing to claim that if sexual intent or arousal is at issue as an element, that this can be admitted, which again, if that were the case, Smith and Boland would have come out differently, because that element is at issue in both of those cases. I am happy to stand for any final questions, but would otherwise ask this court to reverse the decision of the.
I have a couple of questions.
Absolutely.
It seems to me, I mean, we've had a lot of talk about relevance. Relevance is the core legal question here of the pornography to the alleged crimes. And I wanted to ask dig in a little bit to the analogy that you drew at the very beginning of your arguments about horror films.
Yeah.
I'm curious how committed you are to that analogy. If we had a gruesome torture, murder allegation, and the defendant was found to have possessed some of the darkest snuff films that exist on the corners of the internet, would you make the same argument?
Snuff films, maybe not, because at that point we were talking about material that I'm assuming is illegal to possess. It is certainly illegal to film if we're talking, because
Well, it's all acted. It's all.
Oh, and acting. No, then yeah, I would absolutely commit to that.
Even if it looks, I mean, so, okay, how about this hypothetical? I know, thank goodness I've not ever witnessed, but I know that on, again, the dark corners of the internet, there's a cottage industry of videos of people torturing animals.
Mhm.
Maybe that's all fake. Maybe it's AI generated. I don't know.
Mhm.
Is that not relevant to a charge of cruelty to animals?
It could be. I think the line that I'm going to stand on, and I think that makes sense, is whenever the conduct becomes illegal, we're in a different realm. Because we're not talking about art once a crime is being committed. So to the extent that, for instance,
Why isn't, I mean, I won't repeat the titles, but you're arguing that these titles are art.
yes,
And why wouldn't the same exact argument be applicable to an quote unquote artistic depiction of cruelty to animals? Or a snuff film?
again, fine. I suppose it just doesn't logically, again, complete the thought then. Do you think I have a propensity to commit violence because?
Well, that's why I wanted to press into, I mean, you analogized to broadly available, doesn't offend the broad sensibilities of society, R-rated movies that are shown in every theater in the country. And I wanted to really see how committed you were to that. Does that analogy continue into the more edgy, more difficult to find, I'm searching for adjectives, portrayals that really are not part of the mainstream, are not accepted in the mainstream?
I don't think internet pornography is that difficult to find. I think that we have a tendency, again, because.
So again, you're committing to the idea that a fictionalized snuff film is not relevant to a torture murder case, and a fictionalized torturing animals is not relevant to a cruelty to animals case.
I would be very surprised to see the state ever seek to admit a violent movie in a homicide or aggravated battery case. I don't think that they would do that. I think the reason they do it here is because same reason you won't repeat the titles. They're hyper prejudicial. The state knows exactly how a small town jury is going to react when they hear these titles. They are going to be blinded to any other evidence that was presented. They are going to think the person is a sexual deviant who deserves punishment. That's why the state does this. They did it in Sheets. That same prosecutor, after having success on that very point, did it again in Cunningham. That's the whole purpose of it. And with that, I would ask this court to reverse the decision of the Court of Appeals, reverse my client's convictions, and remand for a new trial without the admission of this evidence. Thank you.
Thank you, counsel. Thank you to both of you for your arguments. The court will take this matter under advisement. We are now in recess until 9 a.m. tomorrow.
All right.